Hello, and welcome to Trusts and Estates Weekly. Weekly, there you go. I'm your host, Kevin Bemmel, and we're here every Monday morning at 10 a.m. Pacific time, 1 p.m. Eastern time, with an hour in for Central and Mountain. And we talk about all things related to probate, trusts, estates, estate planning, whether for one's personal finances or for professionals who are interested in helping people with their trust and estate matters, either as their primary business or as an additional line of business for something they're already doing, such as accountants and lawyers. Today, we are going to talk about the probate process. I'm going to jump right into it because there's a lot to cover. Where is here it is. Okay, there we go. So, Trusts and Estates Weekly. There, see, I never know when it's going to work and when it's not. So, everything we do revolves around the three pillars of attainment. We're here in the pursuits pillar, primarily in the finances section. Okay, you're going to see we're going to talk a little bit about relationships as well. And what we're going to do, what we're going to talk about is navigating the probate process, what executors need to know. Okay, so let me sort of set the stage for this. We've covered some of these concepts before, but probate is a legal process whereby the estate, which is the assets of a deceased person, are transferred to the rightful heirs. Now, typically, in the process of going through probate, there will be a will, and that will determine, number one, it will appoint who the executor is, and two, it will determine who the heirs are. Now, when someone dies intestate, and I did a whole show on intestate succession a few weeks ago, so if you want to go to my YouTube channel, you can check that out. If someone dies intestate, meaning they do not have any documents explaining to whom they want their property to go, there may still be a probate filed, okay? And in that case, the person who executes the probate, makes it happen, is called an administrator, not an executor. Okay, so a will appoints an executor. They're typically confirmed by the court, and but when there is no will, then the court, or sometimes, like, for example, I served as an administrator for a will because I wasn't the executor. The person who was appointed as executor, for various reasons, didn't want to fulfill that duty. And so I was appointed in order to handle that job, but I was not an executor then. I was an administrator. Okay, so an administrator is someone the court appoints in order to see to it that the probate process takes place. Now, I'll mention this probably a few times during today's show, but unless the executor, and I'm going to just use the term executor today, although everything I'm saying would apply to an administrator as well, unless the executor is a lawyer who knows the probate process, an executor will have a probate, or I should say a lawyer specializing in estate matters advising him, and probably an accountant as well. Okay, so it would be unusual for an executor to literally do all of these things alone. There's probably going to be a team of people, typically made up of an executor, a lawyer, and an accountant minimally, in order to get these things done. Now, there may also be a professional fiduciary. There may be real estate people involved. There may be insurance people involved. There may be financial services people involved. It'll depend on the size and complexity of the estate, among other issues. Okay, so And I've mentioned this before, we call everybody an executor now. It used to be that men were executors and women were executrixes. I don't think we're seeing that term executrix anymore. So executor applies regardless of whether it's a man or a woman. All right, so I'm going to go through the 5 key issues that executors need to know about in order to effectively go through the probate process, probate an estate, okay? So number 1, the executor needs to understand the probate process, okay? So probate happens under the supervision of a court, okay? So everything the executor does is subject to review by the court. That starts out with the will being validated, okay? Just because an executor presents a will to the court is not obligated to say, oh, okay, check that off, okay? If there's reason to believe that the will being presented is not the most recent will, or for some other reason is invalid, the court does not have to validate the will, okay? So that's the initial process, the initial step, I should say, in the process, okay? Next, well, not, and by the way, these don't happen necessarily in order. Once the will is validated, though, and the executor has what are called letters testamentary. So letters testamentary are what give the executor his authority to act. Prior to that, the executor, although he may be named in the will as the executor, has no authority to act on behalf of the estate. It's not until the court gives him the letters testamentary that he has that authority, okay? So the process then essentially involves identifying all the assets, settling debts and taxes, and then distributing the remaining assets to the heirs. Okay, now it sounds like, hey, 3 simple steps, 1, 2, 3. Not as easy as it seems. First of all, identifying assets. Are they located in more than one state? Are there assets that maybe even the decedent doesn't know about? Okay, so states keep lists of unclaimed property, and those lists need to be checked. Okay, so in order to do a proper job as an executor, that would be something that would need to be done in order to identify assets. Okay, settle debts and taxes. Well, that seems pretty straightforward. Okay, we're going to talk more about that in one of the other steps. So I'm not going to get into a lot of it right here. But again, it's not as simple as it sounds. It's not simply, oh, okay, here's a list of bills. Write checks, write checks, write checks. Well, of course, nobody writes checks today, but make payment, I'm done. Not at all, not at all. Okay. And then finally, distribute the remaining assets. Okay. Again, sounds like a simple step. I've got a will here. It lists the heirs. It says who gets what, or it says in what proportions it's to be distributed, and boom, there you go. Okay. Again, not necessarily a straightforward function. Okay, all of this has to be done with care, with investigation, and with proper compliance with the law. All right, so let's go on. Okay, so let's start out now. Next thing an executor needs to know is to identify and gather assets. Now, when I say gather assets, I don't literally mean like, gather them in your office or something like that, of course. What it means is finding out where they are and making an accounting of the assets. Okay, now assets, there are basically 2 types of assets: tangible assets and intangible assets. Tangible assets are assets that you can touch. Okay, it could be real estate. It could be, and by the way, there's 2 types of tangible assets. Basically, there's real property and there's personal property. So real property is essentially real estate. Could be a house, but there could be other real estate. Okay, The person could have maybe owned a building in which they conduct their business, or they may have investment real estate. Okay, all of that needs to be identified and gathered up in the sense of accounted for. Okay, they may also have a coin collection. They may have artwork. They may have. I did one estate where the decedent left behind a ranch with horses, and they were very valuable horses because they were fairly rare and quite beautiful. Okay, so and by the way, I think I've mentioned this in a previous show. It was an interesting situation because the person inheriting the horses was the child of the decedent, and we needed to get the horses appraised for estate tax purposes. And I hunted around for someone who could appraise these horses, and everybody told me the same thing. Well, the daughter, who was the heir, was the person most knowledgeable about it, and so she's the one who should value these horses. That none of them felt that they could do anything close to as good a job as her. Right? A very really the only time I've ever confronted that particular situation where an heir is going to be providing information for settling the estate. Normally you wouldn't do that. It's a conflict of interest, right? But that's all part of identifying and gathering the estates, the assets, figuring out what they're worth. Okay, especially if it's a large estate, the valuation of the assets can be crucial. Okay, so those are tangible assets. Then you can have intangible assets. You can have bank accounts, brokerage accounts, treasury certificates, like what do you call them? Savings bonds. And by the way, the person may own a business. That business may own trademarks that are very valuable. Okay, so depending on, again, the size and the complexity of the estate, there can be many types of assets, and they can be in various locations, not just necessarily here in the United States. They could be located in other countries as well. Okay, and they could be at a variety of institutions. Okay, I did a situation not too long ago where, even though it wasn't a huge estate, the assets were at 1, 2, 3, 4, 5, I think 6 different institutions, if you can imagine, right? And I mean, it was just a job, gathering all the data. Okay, now identifying and gathering the assets also presumes that the executor will safeguard them. Now, when I say safeguard them, what I mean is protect them from loss in value. So if we're talking about, let's say, a house, okay? Now, perhaps the decedent was the last occupant of the house, so now the house is empty. What needs to be done to make sure that that house does not deteriorate now that no one's living there any longer? Okay, does the gardening need to be kept up? The answer to that is probably yes. Okay, obviously this is general advice. I'm not saying in any specific case, but do you want a house with the landscaping overgrown that is saying to the world, nobody lives here, right? It makes a property rife for all kinds of potential problems, including someone moving into the house and living there even though they're not entitled to. Okay, so if there's investment property, it has to be managed. Now, if the owner was managing the property himself and now he's dead, who's going to collect the rents? Who's going to make sure that tenant maintenance requests are taken care of? Who's going to make sure the bills get paid? So the executor may do that, but the executor may have no experience managing property, and so the executor may need to hire a property manager, okay, or at least a professional fiduciary to make sure that those investment properties are properly taken care of while the probate process goes on. Okay, now that's tangible property, and by the way, let's say there's there's valuable art in the home, but now the home is no longer occupied. Is it safe to keep the artwork in the home, or should it be removed from the home and stored somewhere where not only is it secure from being stolen, but also it's in a climate controlled environment so that I'm thinking, when I say artwork, I'm thinking paintings, so that the paintings do not deteriorate, right? Maybe if they're left in the home, I mean, are you going to, keep the home air conditioned to the proper temperature in order to protect the artwork? Maybe the answer is yes, and that may be fine. But then is the home also secure if nobody's there? Okay, it may make more sense to remove the artwork and store it in order to make sure that it's safeguarded. By the way, let's say there was a wine collection there. Okay, wine has to be kept under proper conditions. So again, are you going to keep, are you going to keep that up? Is there a backup system? Let's say the power goes out and it's very hot, like it has been here, in the United States for the last few weeks, right? And all of a sudden you've got wine stored in a house where it's 90 degrees. If there's any kind of valuable wine there, the value may have been destroyed. So all of these things need to be looked at. Okay, now safeguarding the non-tangible assets is important as well. Okay, and safeguarding them may involve, let's say that there's a CD that's become not due, that's the term of the CD is up. Okay, so now what's going to happen to that money? Okay, is the CD going to be renewed? Is it going to be put into a money market account? So all of that needs to be done, again, to make sure that the value of the assets is maintained as well as possible. Okay, now, merely because the assets drop in value does not mean that the executor has done anything wrong. If there's stocks and bonds in the estate, okay, their value is going to fluctuate. That's just part of the market. So executors are not expected to work miracles and somehow magically keep the estate from feeling the effects of the volatility of the stock market. However, proper steps do need to be taken in order to safeguard not only physical assets from being stolen or damaged, something like that, but even non-tangible assets as prudently as possible. Okay, so identify and gather assets. That's the next thing executors need to know. Next, executors need to settle debts. Okay, now I mentioned this in the beginning, and again, this can be complicated. So first of all, any creditors of the estate need to be notified that their former debtor their debtor is now deceased and is now a former debtor. Okay, so they're entitled to notification. Okay, now notice I say settle debts, address all debts. I don't say pay debts. Okay, it isn't necessarily the case that every debt is payable by the estate. That's something that has to be looked at. Okay, the person dying could terminate the ability of a debtor to collect, a creditor to collect a debt. Okay, for example, if there was a verbal agreement between a creditor and a debtor, okay, between the creditor and the decedent, that the decedent owed the creditor some money, once the debtor dies, all you may have is the word of the creditor that the money is owed. That may not give you, as an executor, the authority to pay that debt. And in fact, if you paid it, you may be wrongly defraying the value of the estate, and the heirs could potentially come after the executor and say, how could you pay this debt? Where is your justification that it was owed? Well, he seemed like an honest guy. I thought I would pay him. Well, that may not be good enough. So in the case of a verbal debt like that, it's something you may, and this is something your lawyer would advise you about. It may be something that the court would need to approve. Okay. So, for example, the creditor may have a memorandum that, memorialize the debt. Okay. And that may need to be submitted to the court since it's not an actual loan agreement. Okay. And if the court says, yes, pay it. Okay. So now no problem. You can pay it. Okay. So creditors need to be notified. All debts need to be addressed. And when I say address, what I mean is they need to be dealt with in some fashion. The executor doesn't want to close the estate, meaning wrap up the probate process, unless all the debts have been addressed. Either they've been paid or they've been adjudicated something not to be paid. And so then the heirs don't have to worry about some kind of liability following them after they've received the distribution of the assets. Okay, now in some cases, a settlement may need to be negotiated. Okay, let's say, for example, that the debts exceed the value of the assets in the estate, thereby not only leaving the heirs with nothing, but there's not even enough to settle all of the debts. Okay, so there may need to be some negotiations to make sure that as many of the creditors get paid as possible. The estate, in other words, may effectively be bankrupt. Okay, that's a very complex situation. It will take a lot of advice from a lawyer and an accountant minimally. There may be more than one lawyer necessary. Okay, and so again, we want to think about settling the debts, addressing them appropriately, not necessarily paying them. That all has to be figured out. Okay, so that's the third thing an executor needs to know. All right, fourth is the executor needs to manage the estate. Okay, now I've talked about this a little bit when I talked about assets, and I mentioned they need to preserve the asset value of the estate. Okay, managing the estate means making financial decisions. Okay, now that goes beyond, by the way, just the day-to-day decisions that need to be made. Let me give you an example. Let's say that there's an estate comprised of a home and a brokerage account with securities in it, stocks, bonds, maybe some mutual funds or whatever. Okay, and let's say that when the decedent died, there were some large medical bills to be paid. Okay. Let me put some numbers to this. Let's say the house is worth $500,000, and let's say the the brokerage portfolio is worth $500,000. Okay, and let's say further that there's maybe about $50,000 in cash in the estate. Okay, so the whole estate is worth about $1,050,000, and let's say there's $200,000 in medical bills, okay, that need to be paid by the estate. Okay, well, it would be reasonable, I suppose, to say, well, I'm going to, me, the executor, I'm going to use the $50,000 in cash to, pay part of the debt. Okay, now you got another $150,000 to pay. What are you going to pay it with? Are you going to pay it with money from, let's say, the sale of the house, or are you going to pay it with money from some of the stocks and bonds being sold? Well, you're thinking, well, I'll just sell some of the stocks and bonds. They're more liquid. It's easier to do that. And hey, I'll just sell $150,000 of those, pay the debt. It's a justifiable debt, let's say, and dos vidania. Okay, let me add a little twist to that. Let's say there's two heirs to the estate, and the will says one heir gets the house and the other heir gets the stocks and bonds. Do you see something happening here? The person getting the house is going to say, by all means, sell $150,000 of the stocks and bonds. because it doesn't affect me. And the person getting the stocks and bonds, the heir getting the stocks and bonds, is going to say, wait, you can't sell the stocks and bonds. How come I get short shrift here? I'm going to pay for all the debts? That's not fair, right? So what are you going to do? And by the way, if you sell the house, you're not only will, let's say you decide, well, okay, then I'll sell the house and we'll split it 50-50 from the house, for the proceeds of the house and from the brokerage account, except for now that you've sold the house, that asset no longer exists and that heir may get zero. Do you see the problems here? So this is why the executor is going to need to make financial decisions, and they can get complex pretty quickly, right? This is also why an executor wants to have advisors to help understand the context in which decisions need to be made, and think about what will happen if certain decisions get made. Okay, so that this managing the estate can be the most difficult part, especially if there's competing interests among the heirs. And by the way, that example I just gave you, that was a real life example, okay? And by the way, this was going on while the person was still alive. They were already fighting over it. She had expenses she had to meet to live, and because of how the will was set up, okay, it meant some asset had to be sold, and the heirs were already arguing over which assets should be sold because, they wanted to get the most out of the estate, and their mother was still alive. Okay, slap the face of those heirs. Okay, now, sorry, my nose is very itchy today. I don't know why. All right, another issue in the management of the estate is tax returns are going to have to be filed. Okay, even if the estate is exempt from estate taxes, it is not exempt from filing a final tax return on behalf of the decedent. Okay, now there may be more than one return that needs to be filed. First of all, there may be a final federal and state tax return to be filed. Right here in California, we have a state income tax, so both would have to be done. Okay, some states don't have a state income tax, so maybe you only have to file a final federal tax return. So that varies from state to state. But there may need to be an estate tax return filed as well. Again, one more reason why the executor needs to have competent advisors to keep track of what needs to be done, okay? And the executor will probably be the one signing that tax return. So he better understand what it says, because he's the one that's going to be responsible for it if there's an audit or any sort of follow-on liability as a result, okay? Finally, the managing the estate includes distributing remaining assets, presumably according to the decedent's wishes. Okay, now if there's a will, hopefully that will makes clear who gets which assets, or maybe better, and this will depend on your situation. Talk to your advisors, but maybe there's not specific assets that go to heirs, just a percentage that goes to the heirs. Okay, so the executor then is responsible for making sure those transfer of assets take place. All right, and I think we've got one more. Yes, okay. Finally, what executors need to know is they must keep accurate records. Okay, now this needs to be interpreted broadly. So not just details of financial matters and distributions, but also communications. Okay, so if there's emails, if there's letters, maybe between various institutions, or maybe other people who are dealing with the estate. Maybe there's correspondence with a broker who's selling a house, okay? All of that needs to be retained. Now, by the way, it doesn't necessarily have to be retained on paper. It can be retained electronically. Okay, but all of that information needs to be retained for a number of reasons. Number one, the court may want to see it. Okay, so if the executor has authorized a particular transaction to take place and there's a question about the propriety of that transaction, the court is most likely going to want to see all paperwork associated with it, whether that's contracts, agreements, emails, letters, whatever. The court may want to see that. Okay, and so all of that needs to be retained. All right. If there's a dispute with the heirs, again, the court will want to see records in order to understand what the executor decided to do and why. Okay, and so you want to retain communications with your advisors as well, so that you can say, well, look, I ended up selling the house because we needed to be able to pay for all these debts. I checked with real estate agents. I checked with a contractor. Here's all the documentation. The house needed a lot of work in order for it to be viable for sale. So given all of that, I decided to sell the house. Okay, and it may be a perfectly legitimate decision, but the court is going to want to see, how did you arrive at that decision in deciding whether it's proper or not. Okay, so you want to keep detailed, accurate records. You also need to document all expenses. Okay, so if the executor has to travel in order to settle the estate, all of those travel expenses need to be documented. Okay, if he is paying for legal advice, accounting advice, whatever, again, all those expense records need to be kept. And again, the probate court may need to do a final accounting on the estate and approve all of those expenses. And so the court can rightly ask for documentation proving that the expenses were incurred. Okay, now, in some cases, an executor may get paid. Okay, although usually that's not the case, but sometimes it will be. And if that's the case, the executor needs to keep very detailed records as to why he was paid what he was paid. Okay, to just be taking lump sums, not a good practice. All right, so that, I think, is the last point. Yep, if you have any questions or you need any help, here's a few ways to contact me. All of this will be listed in the show notes after the show posts to our YouTube channel. So feel free to contact me or drop a comment or question into the chat or into any of our social media. Okay, and here's the legal stuff, of course. And let's go ahead and stop the sharing, because I think we're just about on time here today. So that is what I have for you today on Trust and Estate Weekly. I hope it was informative. I hope it helps you figure out better what needs to be done. And by the way, maybe someone is contemplating having you be the executor of their will. So now you can understand what that may entail, and you can give them a more educated answer as to whether it's a duty that you want to fulfill. Okay. All right. So that's the show for today. Tomorrow, my show is business lessons from the military. It starts at 11 a.m. Pacific time. We'll be continuing our discussion of Marine Corps warfighting doctrine translated into business lessons. And so I invite you to join me then. And then on Wednesday, for People Making Money at 12:30 p.m. Pacific time, my guest will be Jason Young. He's going to be talking about his new book. And let me get you the title of that book real quickly. It's called How to Build Long-Term Energy, Health, and Success as a Ministry Leader. So you'd be saying, well, wait, that's only for ministers. No, I don't think it's only for ministers. I think, in a way, anyone in business today is leading a ministry. Okay, we have our coworkers, we have our customers and clients, and we are working to serve them in the sense of helping them improve their lives. Okay, whether it were a product or a service business doesn't matter so much today. We better be doing something that's improving our customers or clients' lives. Otherwise, we're probably not going to stay in business. And so I think many, if not all of the lessons that Jason highlights in his book will be applicable to your business. You know, even a for-profit business, if we think of ministry as a not-for-profit business, although there have been some infamous examples of ministers, I think, making big profits, but setting that sort of, you know, scandalous stuff aside, whether you're in a for-profit or a nonprofit, I think you will really benefit from hearing Jason's ideas and insights into how you approach your business. And then next week at this time will be the next edition of Trusts and Estates Weekly, and I welcome you to join me 10 a.m. every Monday when we talk about this most important topic. So thanks very much for joining me. Again, I hope you enjoyed the show and look forward to hearing your comments and questions. And I look forward to seeing you tomorrow. Signing off, Marie, darling, you are my bell. All the best, folks.